Okay, hello and welcome. This is the October 6th meeting of the Habeas Standards Work Group. Before we get going on our current draft, I did want to give everybody an update to our deadlines. The powers that be have decided that we'll be presenting the Habeas Standards to the December commission meeting, which means we have to have them finished by the end of November. We're, I think, in pretty good shape to do that. We've got 2 more meetings scheduled now, and we can schedule 2 more meetings out into November as we need them. Keep our same scheduling. But if everybody could just keep that kind of in the back of their mind that we'd like to have a finished product by the end of November. So I am going to share my screen. And there we go. All right, I think last time we left off talking about discovery. So we have the kind of generic statements about lawyers' duty to pursue formal and informal discovery in a prompt fashion upon appointment, and to continue to pursue opportunities for discovery throughout the case. Lawyer must be familiar with all applicable statutes, rules, and case law governing discovery, including those concerning the process of filing motions to compel or to preserve evidence, as well as making sanctions available for when, you should say, defense. Or no, this should say respondent, right?
Either.
You had it right.
Oh, okay.
Yeah. I like saying defense. I like it.
All right. Defense is engaged in discovery violations. So this is, again, our kind of black letter baseline standard. Is there anything that we need to add to that, or is there anything that shouldn't be in there or that we should make more clear?
I think it's pretty
Cool.
pretty good. Yeah. It's got everything
right.
I would suggest.
Okay. So then let's drop down to what we had been calling best practices, but what the commission asked us to change to commentary. So these are our kind of guidelines for cases, but not necessarily things that we'd expect lawyers to do in every case. Submit requests for production to DOJ as soon as they can. Attorneys should follow up on discovery requests. Both of those seem pretty standard. We'll say when I was drafting number 3, I came up with the question of where that 10 days before trial comes from. I don't know if I pulled this from.
Well, there are a lot of trial scheduling. There's a lot of trial scheduling orders that require pleadings to be submitted 10 days before trial. So I would back that up to a lot sooner, though. Personally, if you're going to do a scheduling order, although that doesn't come up that often, I don't know if other people have familiarity with or deal with proposing their own scheduling order. Typically, it's the court.
I agree with Tara that the 10 days before trial seems really, really close to the trial.
Yeah.
Okay.
And I don't know that, because we're talking about that the attorney should propose a scheduling order, so I don't know that it needs to be required by statute if we're just saying you should be asking for this.
Yeah. I think my question was more, I pulled this from somewhere and it said the 10 days before trial. So I didn't know if that was the in there meant something that I didn't know, but it sounds like it didn't.
No, Tara, are the trial memos 10 days before trial, or are they 30 days before trial?
In almost all jurisdictions except like Washington County, and they're 10 days
Okay.
before trial. In most,
Okay.
like in Marion and Malheur, and I typically ask for that too if there isn't a scheduling order that has that.
Yeah, I was just wondering if that's where the 10 days came from.
Probably.
So what if we just say disclose witnesses as soon as possible and end there?
No. I mean, because that could mean that you're disclosing them as soon as I don't. Tara, you, whatever you think, but I wouldn't want people to think that they need to disclose their witnesses as soon as they get them.
Right. I don't know if this is even relevant to standards. I don't, there are court orders, typically trial scheduling orders, that have deadlines for disclosing witnesses. It is typically 10 days before trial, but I think I would change this entirely to say, something like, if you add anything, if the attorney wants to propose a scheduling order, they should, and just leave it broad, they should do it like, prior to the court scheduling order, whenever that is. But I don't know if anything is really even needed here, because I don't think it's going to come up very often.
Okay.
I mean,
so
I
unless
have
this
recently, the one situation I can see this coming up is I'm actually now going to start proposing scheduling orders, because I found that DOC are they're playing games. They're filing motions to dismiss in two parts, and they're doing one motion to dismiss, and then as soon as they can, or as long as they can before trial, like on the cusp of trial, they'll file a second motion to dismiss. And that's been a strategy I've started seeing. So like, but I don't know that that's going to be, broad enough that it would make sense to include here for other people.
Okay, and we're in discovery. That's the
right.
subsection we're under. I'm just
Yeah.
confirming.
Yes.
Right.
I don't know that. I think it should just be like, attorney should be aware, like, they just need to know the requirements of the scheduling order and follow them.
That's
because if
simple enough.
if they blow the scheduling deadline for the experts, then like we just talked about in the post-conviction, it's going to be excluded.
Mm-hmm. So just something as broad as that. Follow all scheduling orders.
Yeah.
Okay.
Well, doesn't 4 cover what we were just talking about?
How about just something like that?
Sure, that
to
sounds
encourage
good.
attorneys to be less passive in accepting what the court is just saying. This is the scheduling order. Okay. Good to move to 4. All right. Be familiar with the applicable statutes, rules, case law governing objection or governing obligation to the plaintiff to provide discovery, file motions for protective orders when needed. Anything else on there that we think we need?
I don't think it should just be plaintiff because it's important that they're keeping track of the defendant's requirements also because they can potentially keep stuff out if the defendant didn't follow the discovery rules.
And honestly, I've never had DOC serve me with a request for production. Not
Oh,
once.
you haven't?
Never.
Interesting.
In habeas?
For like prior medical records.
Never. Wow.
I mean, you've been practicing a lot more currently than I have.
I'm gonna knock on wood for you, Tara.
They do in the federal civil rights cases, but not in state. They've never done it. They missed that entirely. I suppose it could come up.
Oh, I see. You're talking about the second sentence.
Mm-hmm. Yeah, because you're talking about the protective order piece, right, Tara?
Yeah. And there was another reference to plaintiff having the burden to produce discovery. It just doesn't. I've never
It just doesn't come up. That's interesting.
The hundreds of cases I've had from years ago to now had that come up, but Ginger has. So, I mean, I would rephrase this to be more on the side of enforcing the request for production that you've provided to defendant and making sure that they comply with it, because that's where the real problems occur in every case, every single case, and it's getting worse.
Something like that.
Yeah.
But spelled correctly.
Well, wouldn't the third sentence of number 4 go there?
Yep. So then we could change this back to. So we have one for the plaintiff and how to fight about the plaintiff's obligation to provide discovery, and then one for how to fight about the defense not providing discovery.
And I would suggest adding to number 5, a lawyer should file motions to exclude, to add, should file motions to compel and to exclude. Because I found judges don't like to exclude, but they will compel. DOC and DOJ, in my experience. And you should still argue for excluding, but they don't like doing it.
How about that?
Yeah, that's good.
Okay. Which takes us on to the new number 6. Make prompt and comprehensive demand for discovery pursuant to applicable rules and constitutional provisions, and should continually seek all information to which client is entitled. Do we need to be more specific than entitled, or is that a good place to be broad?
Well, that seems good.
But that's not like the discovery standard. It's not, well, I don't know if you, because is it the standard that anything that is relevant or could lead to relevant? So I guess maybe entitled is the best. I don't know. It's just kind of a weird word, but I think I would put 5 after 6. Just makes sense. Like, this is what you should be asking for, and if you don't get it, this is what you should do.
Okay. Can we run through 6 and then remind me
Sure.
to move that down?
Mhm.
Okay, so we'll call that good. And then the list of things you should include in your demands for discovery.
I'd be happy to share my request for production. It's different than all of this. And Ginger probably has one too. I don't know if I'm not going to volunteer you to share yours, but the categories are different in prison and the types of documents you want to request are totally different.
I mean, I would love to get the social media postings from, or
yeah.
I just don't think we're gonna. Yeah, I think that's a good idea, Tara.
Okay.
I'm gonna get a treat for my dog. So yippee. Be back.
Yeah.
I mean, D through F are probably okay. I don't know. I think we should compare it with Tara's.
We can come back.
Yeah.
We'll come back to that next time. Tara, if you'll send me that, I'll update the list.
Sure.
And is discovery the right term for this, or should we be using request for production?
Both are. It's discovery. The request for production is just the formal way you ask for discovery.
Gotcha. All right. Let's drop this guy down. So that it somehow becomes number 10. That's sure.
Is it just Word? Just click on the 10 and if you just click on it, it should say resume. There you go.
Oh, cool trick.
Word's just forgotten how to count briefly. Okay. File motion seeking to preserve evidence, and don't rely on discovery unless you've confirmed that the defense has actually met their obligations. Anything about those last two that we should chat about?
Trying to think of where the motion to preserve evidence, I mean, that could come up for video. Trying to think where else that would.
I mean, this is kind of drawing from post-conviction, but other area would be like the inmate telephone calls, but I don't know if you really see that in habeas. Heights
for sure. Have you ever filed a motion to preserve the evidence, Ginger?
I haven't filed a motion. I've just sent a letter to administration. Have you?
That's what I did as well. I did a letter to defense counsel and people, but I never did a motion.
I don't, if I have, it's been very far and few between, in the sense that maybe it's been one.
But how about we change file motions to take appropriate actions if the.
Yeah. I like that.
Yeah. Okay. Which drops us to 4.2, the theory of the case. Develop and continually reassess a theory of the client's case that advocates the client's goals and encompasses the realities of the client's situation. And then the commentary there. Any comments on any of that?
I'm kind of hitching up on using theory of the case because that's really it's a criminal defense. I guess it applies as well to the claims, but I might use a different word for that. I mean, the claims for relief could substitute.
Okay. What do we think?
I like that because, well, I don't mind either of them. But I think claims for relief probably, yeah, I mean, because you might have multiple different claims that don't necessarily all go into the same theory.
Okay. 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 Anything else on that section?
You might add to like number 4, just practically speaking, claims will change. You'll get more information as the case develops. And they should be, an attorney should be ready to amend the replication with a new claim as the case goes on.
How about that?
I would take out the theory and then just leave it.
Take that out.
Yeah. Or just a lawyer should expect the claims to change.
Okay.
Correct.
All right. So now the replication bit. Lawyers should review the plaintiff's initial filing and amend the filing as needed to give notice of all anticipated claims. As far as the baseline, what you need to do, how's that?
Well, it's not really as needed because you need to use the petition as a jumping point, but what you're really doing as your first complaint is the replication, and you really have to file that. It's not really like permissive or a question as to whether you will or won't.
Mm-hmm.
But is the as needed part talking about what needs to be in it? Not that it should, it's not whether or not the replication needs to be filed, it's what needs to be in the replication.
Yeah. I guess I would make that clearer and say, and amend the filing for the replication to give notice.
Yeah.
So review the plaintiff's initial filing, amend the filing to give notice of all claims or To give notice of all anticipated claims.
Just but when you're talking about the filing, you're talking about the pro se.
Yes.
The initial, right? I would, if.
Yeah.
And amend, oh, okay.
That has a hyphen.
I would just say and amend the pro se filing to give notice of, I don't know.
I think it has to point to the replication and have that language in it, but we don't, maybe trying this with different language. I think really like the emphasis on the replication is that you have enough discovery, that you've had experts review, the potential claims, and then, you can file a sufficient replication, understanding it may change later.
Yeah, and I don't know, Tara, what do you think? Do you think that the replication is, it's not like an amendment of the pro se filing?
It's not, because it takes the
its
place.
Own thing. Yeah.
Yeah, that's the problem, is under the statutes that the petition or the initial petition pro se petition, it disappears when you file the replication.
I mean, it's just, yeah, you're not amending the pro se filing. You're filing a replication.
Yeah.
Okay.
And it's more like
we can add,
in drafting the replication, a lawyer should review the plaintiff's initial pro se filing.
Sure, yeah.
Yeah.
Maybe in drafting the replication.
add that R, that really changes the meaning there.
And
I would say, and have thoroughly interviewed the plaintiff.
I don't.
And you might not have enough discovery. The point of the replication is it's not supposed to take that long, but the timelines will come up you often too quickly. But it shouldn't be like, 8 months until you file, you've got all your ducks in a row. It's just you want enough discovery, and I get experts on as soon as possible, but you want to have some urgency to it.
Is there a statutory timeline for when these have to be filed?
I don't think it's statutory, but it is like with all immediate speed, judicial scrutiny, and the timelines are set by the court, and they're typically not that long after the petition is filed, a matter of weeks.
Okay.
Well, for number one, I would just say the replication needs to be amended if this happens. Tara, do you attach exhibits to replications?
The only thing I sometimes attach, and I don't really do that anymore, has been an expert letter.
Should we add something about lawyers attaching exhibits or no?
I don't think it's necessary. I mean, you don't need to. You don't need to cite law either. In fact, I think it's preferred you don't.
Well, and for that, we have the citation for that in the PCR.
Mm-hmm. How's that? Or should we just include the standard from the PCR document?
I don't have a preference. Oh, we're just saying we had some sort of citation if you wanted to put it in there.
I think it was this specific PCR rule though about.
Oh, it was? Okay.
I think so.
We'll just leave it there.
Okay.
Okay. Anything else that we need as commentary for filing replications? Things that y'all think are good ideas?
That seems pretty good
Okay.
to me.
Yeah.
The only I would consider making one more claim, but one more adjustment. When you say a lawyer should file a replication that clearly gives notice of the client's claims for relief, I think that there is an ORCP that talks about what notice is. We could consider replacing the actual language with the clearly gives notice piece. Okay.
I'll take a look. If it's not too
Yeah.
cumbersome, we can do that. If not, I think just using the term notice has enough of a legal connotation that people ought to understand, but I guess if we're sticking with people ought to understand, we might be. Yeah. All right. But let's see. So pre-hearing motions and notices. Research, prepare, file, argue appropriate pretrial motions, which I guess should be pre-hearing motions. And notices, whenever there's reason to believe they would benefit the client. Lawyer must be knowledgeable of all motion and notice deadlines and that may apply to their case. Lawyers may not miss filing deadlines.
What does it mean to research, prepare, file, and argue and notice?
Well, like research, prepare, and file apply. I'm not sure you ever argue and notice, though. I think of any time I've ever had to argue about giving notice. Of course, that would all be in criminal context, but I assume that.
Yeah, I think you could take that out.
Okay.
The notices. I can't think of when that's come up.
No, I think you can leave.
Oh,
I think you can leave that because we talk about notices in the next sentence.
I don't know what a notice is. I'm just gonna say it. What's a notice?
Well, I was thinking that maybe it was like almost like a scheduling order in this context. That's what my issue was. I wasn't sure what a notice was in this
Yeah.
context.
It's pulled from the criminal context. If it's
okay,
where you have to give notice of certain things, like
yeah,
notice
yeah,
this
no,
defense or that defense.
Okay.
But I don't know if it translates over, and so I left it rather than take it out. But if it doesn't translate over, let's just take it out.
I don't think it does.
Okay.
I can't think of any time I can't think of any time that's come up.
Then we will take it out.
I mean, can you think of a context, Tara, where they would file a pretrial notice to exclude an expert witness? I think they would just object to it.
Well, they don't, because that would be, you don't have to disclose your expert witness.
Yeah,
first of all. So they wouldn't have any bearing. I mean, unless they just don't know. But it just has, I can't think of that ever coming up or that language. Yeah.
I can't either. Okay.
It's your deal.
So then let's cover the commentary, and then we'll come back to the question of where we put depositions, because I do think we need to discuss where we include depositions in this. Lawyers should respond to the defendant's motion to dismiss within the time frame, demonstrate facts and controversy necessary to win a motion to dismiss. Is there ever a reason not to respond to the motion to dismiss?
You want to lose your case.
Yeah.
You don't want to
Is there a
litigate
good
it.
reason not to respond to the motion to dismiss?
Never.
Okay. Just checking.
Not that I know.
Yeah.
I don't know if you want to add this. Sorry.
No.
But a motion to dismiss is considered the equivalent of a summary judgment in habeas.
Mm-hmm.
And that does come up because in many different ways. It comes up in terms of the deadlines, which are different for motion to dismiss and a motion for summary judgment. It comes up in terms of conferral requirements. So I think that's a point to make, just so it's flagged. Don't have to go too much into it, but it does change things.
Like that?
Yeah, and you could say in habeas. Just to make clear, this isn't a general rule.
The habeas equivalent to motions for summary judgment? Or would it be in habeas?
I would just say in habeas.
But are the standards the same?
No, they're actually not. Conferral is it's arguable, but conferral is different. The dismissal without prejudice or with prejudice is different under a motion to dismiss and a summary judgment motion. And the timelines are different. That there's some substantive difference. Whether you can voluntarily dismiss a summary judgment is different than a motion to dismiss.
That's very confusing to me.
In what way?
Motions to dismiss are the equivalent to motions to summary judgment in habeas. So the standards are not the same. Okay. Lawyers should know the rules. Yes.
We could say as well as instead of and.
The part that's confusing to me is the part that they are equivalent.
Well, that's just what the case law says. I mean, that's how the case law puts it.
Okay.
If we said that lawyers should know the rules surrounding motions to dismiss, do you think that's enough to encompass that they should know that case law without talking specifically about summary judgment?
No, I think you need to be specific. I mean,
yeah.
There's no reason why somebody who's new would put that together.
Okay.
I would add, though, that the standards are different in some ways instead of the standards are not the same, because they are the same in many ways, but in some ways they're not.
Mm-hmm.
Okay. Good with number 1 then?
Yes.
Number 2. Decision to file a particular motion or notice. We're taking out notices. Particular motion should be made by the lawyer after thorough investigation, discussion with the client, and considering the applicable law in light of the circumstances of the case. Anything with any of that? Okay. So, what issues should folks be considering for pretrial motions? I think this is just pulled from what we did for the criminal standards, so we can probably take it all apart. Is pretrial custody ever a thing? I mean, I know it's always a thing, but is it ever a thing for motion practice?
Only if they're moved, but it's not a motion issue necessarily.
Yeah.
Honestly, I never have filed a pretrial motion. I respond to them. But in habeas, you're only motions practice is disallowed, except for motions to dismiss, which are motions which are also kind of motions for summary judgment. So really the only motion you should be able to file is that on either side. I mean, motions are filed, but they're not like, substantive to the nature of the case. You could file motions in limine and judges like that before trial. So that can come up.
And you could file a motion for summary judgment.
Yeah, for both sides. I think, Ed, you filed one, didn't you? Motion for a summary judgment in the habeas?
Probably. I don't recall, because when you started talking about the motion to dismiss and the equivalent, I'm fuzzy. But yeah, I may well have done that.
I think you did.
Okay. So let's see. So you can file motions for summary judgment. Does competency ever come into it? I assume not, if there's no, unless there's a right to be competent in habeas. Okay. The constitutionality of statutes, would that be a motion in limine that you'd file, or is that just something that you're not really arguing about? Hi, Wesley.
I don't.
No.
I mean, maybe like in the really old parole board rules, but that would be what the habeas would be about.
Okay. Jurisdiction, I think we cover other places when we're talking about moving the client around. Change of venue the same.
Well, except in that COVID case, Tara, how did you guys get the get it moved from a Malheur County judge to the Multnomah
Oh.
County judge?
She's a senior court judge. She's a
Oh,
Plan
okay.
B judge.
Okay,
Yeah.
okay.
Well, yeah, Multnomah judges, I guess they didn't have anything to do in Portland, so they did some of those cases in outside counties.
But it wasn't because of,
She was actually just regularly on the bench. She's on the federal bench now. Judge
Yeah.
She was? I thought she
Baglio.
was a Plan B. Not a
No,
Plan
but
B?
just in
Oh.
No,
same
she-
as like Judge Swade, they weren't allowing people into court, so
Yeah.
they stepped up to help out with other cases from Multnomah.
okay,
Mhm.
but my point is that you guys didn't do any sort
No.
of motion to get a different judge or anything like that.
We
Okay.
know
No.
everything was recorded by Malheur County. They
Okay.
conduct as if it was Malheur.
Okay. So we can pull that, change
You
of
can't do D
say again?
or B. I'm sorry, you can't do B.
Okay. Removal of the judicial officer, so we'll leave that one.
You might want to note on that one that it has to happen basically within 24 hours of the subject judge you wish to disqualify touching the case. So you have to be on that.
Let's see. We've talked about protective orders. I assume Brady and Cartwright don't apply, but I don't know that for sure, I suppose.
They do not.
Okay. So we got protective orders and motions to exclude or violation of discovery rules. Let's see. This one we can probably pull.
Oh, no, E can apply. Yeah.
Okay. Keep E, which will now be D. Right to an expedited hearing we wanted to keep. I assume the continuance we're okay with. And
But there's also, I don't know if it goes here, a motion for extension of time for pleadings.
okay. Right there. There we go. All right. So then within the evidence, assume you can file relevancy objections. I don't know that, would you all ever file competency objections to a witness?
I haven't. Definitely admissibility of witnesses, but not by competency.
And would you file a motion in limine for that, or would you just argue it? Would it go to the weight or admissibility?
It depends. I usually would just argue it at the beginning of the trial, because we just don't have our pleadings with enough time to prepare those kind of motions.
Okay. Would you, when you say argue about it, would it be like at the time the defense called the witness, or would it be before witnesses?
Usually it's when they call the witness and in the witness's testimony for lack of knowledge. Personal knowledge is a big one, or lack of expertise, whatever.
I mean, Yeah, I mean, I suppose somebody could do it beforehand and it wouldn't necessarily be wrong.
Well, I guess the question is, what should people be doing? Should they be doing it ahead of time as like a motion in limine, or should they be doing it during trial?
It just depends on what you're trying to do, really, in the facts. You should be prepared to do both. I mean, if you have knowledge that you need to bring a motion in limine before trial, great. I would say most of the time it's going to come up during trial where you have, because typically they don't even give me witness declarations anymore. I mean, they're just like, yes. And their trial memos are like 5 pages long. So, they keep it all very close and you can't really, you have to be in trial to be able to deal with it.
That seems rude.
It's rude. It's very rude.
Okay. Does prior convictions ever come up?
No.
Wouldn't think so. Same with other acts.
Well, I mean, it might now if
well,
ODOC starts to hire these people back after they've been released from custody, but
Ah, yeah.
I'm talking about the COs and the
Yeah.
medical
yeah,
staff.
We'll pull that one.
Criminals all. Who's a real criminal?
That's right.
Other acts evidence, probably in the same boat, not going to be
Mhm.
generally relevant.
Yeah.
And reputation evidence.
That can come up with.
Yeah, I wouldn't take that out.
Yeah, that can come up.
And do y'all ever run into the rape shield law stuff?
No.
No. Okay. Let's move and back up here and move on to 4.
Well, let me ask Tara something though. Have you had cases where you've needed information about other AICs and where they've refused to give you that information?
I use now AEOs, attorney eyes only.
Sure.
And it has a line about requiring information to be unredacted.
So I'm just
yeah.
wondering if that is a pretrial issue that people might need to know about and deal with it pre-trial.
Yeah, that's a good point. Instead of just motions for protective orders, you could specify including AEOs for cases, where discovery is going to involve other prisoners. But you have to use your own, and it has to have a line about producing unredacted materials, because otherwise they'll give you their version of an AEO compliant document and it will be entirely redacted. You can't read anything.
How's that?
Yeah.
Well, it's an attorney eyes only SPO.
Yeah.
Sorry, my mind just blank. SPO.
Supplemental.
Supplemental protective order.
Stipulated protective order.
Well, I call them supplemental because I usually litigate them. So they're not usually.
Just call it a PO. Just call it a protective order.
Yeah.
Okay. Dropping us down to number 4. Before deciding not to file a motion or to withdraw a motion already filed, lawyers should consult with the client, carefully consider all the facts in the case, applicable law, case strategy, and other relevant information, including burden of proof, potential advantages, and any of the A through D that we need to figure out.
I don't know how 4 would apply.
I guess if there's not much motions practice, there's not much withdrawing of motions.
I mean, sometimes your client will press you to file a motion for summary judgment. And you'd have to decide whether or not to file that.
Yeah.
I mean, I guess their clients do try and. There used to be all those guys that tried to make you file the UCC stuff, but are they really still around, Tara?
I haven't gotten any in a while. I don't get many habeas people who are like PCRs. I got a lot of that. I don't get many habeas clients who are like,
Yeah, but
you got to file it. But it's not bad to have something kind of general here.
maybe just number
So
4.
maybe just leave it at that and take out the
Yeah.
including. Okay.
Yeah.
We can do that. Okay, which takes us to 5.3, filing and arguing motions, and also takes us to 2 o'clock.
Are there really 32 pages of this document?
I hope not. Did I leave some notes in?
I hope so. Okay, good.
Nope, there really are 32 pages. But there are some that look like that.
Okay.
Stop.
So we are about 4
Halfway
standards
done.
away from being done. Get back to where we were. And hopefully some of these will not involve quite as much discussion.
Okay.
But I will send this document back out after I've made a couple more edits. And if you all ever want to read over it, and feel free to use track changes and comment and send it back to me, and maybe we can expedite some of the discussion that way. Then unless anybody wants to hang on and keep pushing through these, it is 2 o'clock, which is the extent of our meeting time. So I do want to be respectful of your schedules.
I got to do something with this dog, so I got to go.
Yeah.
All right. I give dogs priority, so. All right. So thank you all, and I will see you in 2 weeks.
Bye.
Thanks.
Bye.